When a state redefines America's most common rifle as a weapon of war, every single right is one bad legal definition away from erosion. In Illinois, the Protect Illinois Communities Act, PIA, directly targets AR-15-style rifles, slaps harsh magazine capacity limits, and leverages the Illinois State Police for draconian compliance. Following Heller, McDonald, and Bruen, this law launches a fresh stress test against the Second Amendment's legacy and the very concept of arms in common use. Yet the Seventh Circuit Court permitted key restrictions to persist during litigation, even as a federal judge in 2024 later struck down core provisions. Justice Thomas has already issued a sharp warning against lower courts attempting to sidestep Bruen, with the U.S. Department of Justice now filing amicus briefs that directly challenge these categorical bans. This is a fight that supersedes a single statute. Tonight, I will unpack the law, the financial stakes, and the clear path that could lead this crisis straight to the Supreme Court. I'm telling this as one continuous narrative, because that is precisely how legal threat feels when you are the citizen forced to comply. Illinois avoided a simple outright ban on semi-automatic fire. Instead, the Protect Illinois Communities Act, PICA, rerouted the legal landscape by declaring specific rifles and accessories forbidden contraband if configured with particular external features. A simple pistol grip here, a collapsible stock there, a threaded barrel, or a flash suppressor, and suddenly the same gas-operated carbine becomes a felony risk. The official theory is that these externals somehow transform a commonplace rifle into a uniquely menacing object. But the cycle of operation remains utterly unchanged. 1 round per trigger press. Gas is vented to drive the bolt, and the shooter bears individual responsibility for each shot. The catastrophic result of these feature tests is something far worse, a bureaucratic mechanism to convert mere furniture into a felony because the legal label hinges entirely on cosmetics. A car with a spoiler is still a car. A rifle with a different grip angle is still a semi-automatic rifle. That is why the constitutional framework is the controlling factor. Post-District of Columbia versus Heller and McDonald versus Chicago, the Supreme Court established the Second Amendment protects arms in common use for lawful purposes by law-abiding citizens. Then, in New York State Rifle and Pistol Association versus Bruen, the court demolished subjective balancing tests, replacing them with the text, history, and tradition standard. The inquiry is simple to state but demanding to satisfy. If the conduct falls within the amendment's text, the burden of proof shifts entirely to the government. The state must then demonstrate a well-established analog from our historical tradition of firearm regulation. They cannot rely on policy arguments about safety, predictive models, or emotional appeals. The government must cite history that is comparable in its justification and close in how it burdens the right. This discipline is the court's oath to the Constitution, which is designed to withdraw certain choices from the whims of majorities and temporary officials. It does not bend to political fashion or public fear. Consider the cold, hard fact of common use. Modern sporting rifles, MSRs, on the AR platform are owned by tens of millions of Americans. Detachable box magazines ranging from 11 to 30 rounds are measured not in thousands or even millions, but in hundreds of millions. These are not boutique curiosities, they are the ordinary tools of contemporary marksmanship, deployed for home defense, competition, training, and recreation. The Supreme Court's phrase, dangerous and unusual, is conjunctive for an essential reason. Every arm is dangerous in the abstract, time 300 milliliters. But an arm that is ubiquitous and lawfully used every single day is the precise opposite of unusual. This distinction matters because the government's labeling strategy cannot negate the empirical, undeniable reality that ordinary law-abiding people rely on these arms. If every modern characteristic that improved ergonomics or performance could justify a ban, the right would shrink with every innovation. The Second Amendment is not a museum pass. It protects the arms people actually keep and bear today. Illinois' legal fiction leans heavily on externals, precisely because externals are simple to catalog, list, and target. A pistol grip is easily spotted across a dealer's counter. A bayonet lug can be photographed and circled in court exhibits. Whether a muzzle device is a flash suppressor or a brake can be litigated to bankruptcy with expert diagrams and cross-examinations. This ease of administrability is an insidious temptation for lawmakers. But constitutional law is not a checklist exercise. A statute that turns entirely on furniture rather than core function risks swallowing the very protection the amendment supplies. The people are not protected only when they own awkward, heavy, or anachronistic tools. They are protected when they own arms in common use for lawful purposes, period. Because semi-automatic operation does not originate from a collapsing stock, the state's obsession with cosmetics fundamentally exposes the massive gap between mere appearance and the functional reality. That is the legal gap the courts are grappling with now, and it is the gap this entire broadcast is dedicated to closing with absolute clarity. Procedurally, the initial rounds of litigation rarely present as a clean, simple merits trial. Plaintiffs are forced to start with temporary restraining orders and preliminary injunctions. These are emergency judicial tools that compel judges to quickly forecast the likelihood of success and balance the equities before a complete factual record even exists. If a district court denies the injunction or an appellate court issues a stay, the challenged law tragically remains in force while briefing and discovery drag on. This legal posture is the source of the compliance whiplash felt by citizens. One headline claims a restriction is blocked. The next declares it is back in effect. None of this temporary maneuvering determines the final constitutional answer. It only dictates whether the state may enforce the rule while the ultimate foundational legal dispute is in progress. Understanding this precarious posture is critical to explaining the chaotic rhythm of the last 2 years. Early lawsuits were filed, injunctions were aggressively sought, some granted, some denied. Stays were subsequently issued, and oral arguments were scheduled for months, sometimes a year out, while the bureaucratic calendar kept turning. The Seventh Circuit's preliminary rulings in Illinois and a neighboring city permitted the feature-based restrictions to persist throughout this emergency phase. These decisions interpreted Bruen in a way that, according to challengers, treated historical analogies too generously and the common use principle too narrowly. The state's legal briefs consistently emphasized risks associated with rapid fire, public terror, and mass harm. The plaintiffs, conversely, emphasized the historical fact that semi-automatic operation and detachable magazines are not novel and that history demonstrates no categorical bans on widely owned civilian rifles. This fundamental clash frames the single question that will ultimately control the merits. May a government treat a popular arm as unprotected simply because its appearance resembles a military service weapon, even though its core function is squarely semi-automatic? If mere resemblance were sufficient, almost any modern ergonomic improvement would immediately be deemed constitutionally suspect. The Supreme Court's Bruen methodology resists that fatal slide by demanding real history, not simple rhetorical equivalence. A district court in late 2024 confronted this precise question on a fuller, developed record and decisively concluded that core portions of the law could not stand under Bruen. The court did not dismiss public safety as irrelevant. It considered it as insufficient without necessary historical grounding. The judge looked straight past generalized appeals to emotion and instead demanded analogies with comparable burdens and comparable justifications. Restrictions on exotic concealable traps or unusual melee weapons offered no comparative analog. The court also thoroughly engaged the ubiquity of the arms and the magazines at issue, reasoning that tools owned by millions for lawful purposes could not, under any good faith standard, be deemed unusual. That landmark ruling did not end the case. Appeals immediately followed and stays were sought. However, it vividly illustrated precisely how the merits analysis functions. when the strict instructions from Heller, MacDonald, and Bruen are applied with judicial fidelity. Crucially, it gave the public a rare look at what a completed record can prove, rather than what an initial legal forecast merely predicts. Meanwhile, the Supreme Court's own signals are sharpening the path ahead. When Justice Thomas observes that AR-15-style rifles are undeniably in common use today, he is not offering cultural commentary. He is reminding the lower courts that the threshold questions in Bruen are dispositive when answered honestly. If the arm is commonly possessed for lawful purposes, then the government's entire task is to produce history, not to dress up political predictions as historical analogs. That guidance has massive implications for legal strategy. It advises litigants to construct strong cases built upon developed factual records and clear, clean legal issues, rather than merely rushing from one emergency order to the next. It instructs the courts of appeals to apply the method as written, and it delivers a basic but crucial message to citizens. If the Constitution protects a thing, popularity is a shield, not a vice. The modernity of a design does not defeat a right that was written to endure, as technology itself changes. Now, add the federal executive branch to this already high-stakes scene. The United States government does not directly command state legislatures, but when the Department of Justice, DOJ, files amicus briefs in appellate courts or at the Supreme Court, its views carry substantial weight. These filings are meticulously crafted to explain how Bruen should operate, warn against substituting political labels for functional reality, and formally recognize that modern magazines are integral parts of modern arms, not simply detachable contraband. While they do not guarantee outcomes and are not binding orders, they stand as the national government's official understanding of the Second Amendment's framework, and courts read them with extreme care. For ordinary viewers, that means this is not a parochial fight. When the federal government weighs in, it is because the questions presented will fundamentally shape the law far beyond the borders of a single state. That is exactly why the next merits decisions in these cases are drawing such intense national attention. Now, translate legal doctrine back into daily dangerous life. If you own a rifle in Illinois, your compliance nightmare begins with hardware: barrel threads, muzzle devices, forward grips, stock type, and the capacity of every single magazine you possess or transport. It continues with bureaucratic process: how the state police define vague terms, how they decide to open and close registration windows, what narrow exemptions genuinely exist, and what onerous record-keeping is imposed on licensed dealers and private transfers. None of this compliance is glamorous. All of it is absolutely necessary until a final judicial decision is rendered. If you live outside Illinois, you are not a passive spectator. The legal reasoning forged in these cases will either be upheld or used to strike down similar laws being enacted across the entire country. A Supreme Court merits opinion will bind every single circuit instantly. It will standardize the crucial questions judges are permitted to ask and the evasive answers governments are required to stop giving. That is the fundamental promise of constitutional law in a nation committed to equal justice under law. Numbers frame the stakes of this crisis when a policy declares a class of arms owned by millions as contraband, and a class of magazines that outnumber the adult population several times over as illegal. It is not merely tweaking at the margins. It is aggressively redefining normal. That is why precision is mandatory in public debate. If you carelessly call an AR-15 a machine gun, you will never grasp the actual legal argument. Semi-automatic operation is the controlling functional fact. If you label a 20 or 30-round magazine an exotic accessory, you catastrophically misread ordinary practice at ranges and in matches nationwide. The only right answer to violence is to punish violent actors swiftly and surely, not to convert ordinary, common hardware into signs of guilt. Citizens deserve laws that target misuse, not ownership, behavior, not appearance. And the Constitution insists that any departure from this principle must be justified by history, not by hysterical headlines. The immutable principle that ties this entire threat together is older than firearms policy itself. The Constitution restrains government the most when that restraint is least convenient for politicians. It is easy to protect a right when the object is fashionable. It is exponentially harder when the object is polarizing, loud, or deeply misunderstood. Bruen did not state that only quaint muskets are protected. It stated that the people's arms are protected and that the government must justify any restriction with genuine comparable history. That is why these feature-based tests, which rely on cosmetics and administrative checklists, are on a direct collision course with established doctrine. The state is free to regulate misuse, punish crime, and set rules consistent with historical practice, but it may not downgrade a fundamental right into a licensed privilege simply because a rifle wears the wrong furniture. The impending merits stage will no longer hide behind cosmetics. Here is my bottom line. The PIA is not a harmless policy tweak. It is a stress test of the Second Amendment in the wake of Heller, MacDonald, and Bruen. Laws built on feature-based cosmetics risk converting ordinary semi-automatic rifles and magazines into felony contraband by label alone. The Seventh Circuit's interim posture absolutely does not settle the merits, and a federal court has already shown why the history test is the only metric that matters. With the Department of Justice filing an amicus brief and Justice Thomas powerfully emphasizing arms in common use, the next clean case is poised to reach the Supreme Court. Know your obligations, strictly follow guidance, and stay level strong, intensely engaged, because constitutional rights shrink fastest when citizens go silent.